Good afternoon, everyone. Thank you for joining us for this webinar on the employer's positive duty to stop sexual harassment and discrimination. I'd like to begin by acknowledging the traditional custodians of the land which we meet today, and I pay my respects to elders past, present and emerging, and any Aboriginal or Torres Strait Islander people here today. My name is Linda Hart and I'm one of the principals at Hunt & Hunt, and I head up the Wills and States practice. I'll be the facilitator for this webinar. I'm involved in the Hunt & Hunt's Diversity and Inclusion Committee, which plays a role here in educating and embracing the diversity within our workplace and to celebrate the different perspectives and positive values that our team members bring based on their backgrounds and faiths. I'm also the Secretary of the Victorian Women Lawyers, and our key objective is to promote the understanding and support of women's legal and human rights. Our objective is to include identifying, highlighting and eradicating discrimination against women in the law and advocating for change. As we will hear, although there has been some progress in Australia to create safe and respectful workplaces, sexual harassment and discrimination continue to exist, and no organisation or industry is immune from this. Under the new laws, employers will have a new positive duty to stop sex discrimination and harassment in their workplaces before it happens. In this webinar, David Thompson and Richard Google will outline the scope of the new positive obligation and what is required of businesses to meet them, and explain how businesses can address compliance under the overlapping regulatory regimes. If you have any questions as we go, type them in the comments and I will monitor these and ask our speakers at the appropriate time. David Thompson will be our first speaker. David was previously the managing partner at Hunt & Hunt, and he now works as a consultant. David has over 30 years experience in employment and workplace relations law. David, I'll hand it over to you.
Thank you, Linda, for that introduction, and welcome everyone to today's session. Now, the Commonwealth Sex Discrimination Act was amended from December last year, and it now places a positive duty on businesses and organisations to prevent workplace sexual harassment, sex-based harassment, and also including hostile environments on the ground of sex. Under these new requirements, businesses and organisations must take reasonable and proportionate measures to eliminate these things as far as possible. The AHRC, the Australian Human Rights Commission, has also issued guidelines in relation to these issues for compliance and obligations. And these were only released just over 2 months ago in August. I'm just having a technical issue changing the slides. Anyway, I will be talking about today the drivers for change, what's wrong with the system to date, and the new positive duties. Also talking about or finishing up on other related legislative changes, being changes to the Fair Work Act and health and safety regulations. Can I have some assistance there? Yes, someone might be able to help me change those slides. And then Richard Scoogle will be talking about the AHRC's compliance guidelines, and this is a critical part of the presentation, and also what other regulators require. And then we'll be finishing up with a case study by one of our young lawyers, Harriet Whiteley, on the Productivity Commission, followed by questions. Okay, so briefly, I'd like to look at firstly, the provisions of the Sex Discrimination Act, the SDA, before these amendments, and these haven't changed at all, but there's always been a definition of sexual harassment involving unwelcome conduct, being a sexual advance or request for sexual favours, or other unwelcome conduct of a sexual nature. And the test is a reasonable person would have anticipated that the victim would be offended, humiliated, or intimidated. And this takes into account things like power relationships between the perpetrator and the victim. There's also a concept of vicarious liability in both state and federal legislation, and that means a business is legally responsible for the unlawful harassment engaged in by its employees or its agents, such as a contractor you might use, unless you took all reasonable steps to prevent the conduct from occurring. Now, the case law over the years has established that all reasonable steps to prevent this conduct includes having relevant policies in place, appropriate complaints procedures, and training on these issues so people understand what's unlawful and what's not. And finally, having an environment where these policies are being given more than mere lip service, i.e. you've got to have an appropriate culture to deal with these issues. If you're doing all of those things already, then you might be a little way down the track to taking some positive steps, some of the steps that are required under these new requirements. Next slide, please. Now, because we have a federal system of government, we have state and territory laws dealing with sexual harassment as well, and they are broadly similar to what the current SDA requirements are, except in the Victorian Act, we've had provisions for some time, since 2010, where there's been a duty to eliminate discrimination and sexual harassment by taking reasonable and proportionate measures. Now, these provisions in the Victorian Act have been criticised for having no teeth, as prosecutions cannot be issued for failing to comply. And also, there hasn't been a major focus in Victoria on prevention. And that's what's going to change, or one of the things that will change. Next slide, please. So what's been wrong with the system? I'd like to talk a bit now on what the drivers for change are, and there have been many of them, but three of the most important drivers are outlined in these slides. Firstly, the AHRC, the Human Rights Commission, has been conducting 4 yearly national surveys in workplaces on sexual harassment, and it released its 5th survey result in November last year. And I've got a few slides in a minute that'll talk about some of the figures. We've also had the Respect at Work report from Kate Jenkins, our Sex Discrimination Commissioner, that was released in 2020, and she remained our Commissioner until March of this year. And very significantly around the world, we have had the development of Me Too and similar movements. And these have precipitated a global discussion about sexual harassment and gender inequality, so that victims who have previously been silenced have now found a voice, and that's been a great thing for them. For example, in the USA, this made public numerous harassment allegations from different women about Harvey Weinstein, movie producer. In Australia, in recent years, it's brought publicity about the conduct of former Lord Mayor of Melbourne, Robert Doyle, actor Craig McLachlan, and in 2020, a judge of our High Court, Dyson Hayden, where complaints were made and investigated, and he was found to have engaged in unacceptable conduct towards his associates. We've also seen the serious allegations made by Brittany Higgins, parliamentary staffer to the then Defence Minister Linda Reynolds, about another fellow staffer, Bruce Lehrman, who she says raped her in the Minister's office at night time when she was intoxicated. Now, the manner in which the criminal trial was aborted and what Brittany Higgins went through in the process is a clear example of why many women do not want to report harassment. Next slide, please. Now, I've got several slides talking about the AHRC's figures in relation to its recent 4-year survey, the 5th of them last year on harassment in workplaces. And in the last 12 months, about 1 in 5 people have been sexually harassed at work, a very high figure. In addition to that, in the last 5 years, about 1 in 3 people, or a third, a very high figure, have been sexually harassed at work. And that's included 41% of men and 26% of women. Sorry, the other way around, 41% of women, 26% of men. Next slide, please. And the next slide, I'll leave this to for you to look at your leisure when you're being sent this deck, but it lists the 5 most common forms of workplace sexual harassment in the last 5 years. And of those, the 2 most commonly reported types of conduct have been sexually suggestive comments or jokes, and also intrusive questions about private life or physical appearance. And this conduct also often develops further. And in my experience, it also often involves 2 types of perpetrators. Firstly, the innocent victim or innocent comedian who uses sexually suggestive comments to start the harassment process. And after a complaint is made, their response is, "I was just joking, what's the problem?" And the other type of perpetrator often has a power relationship over the victim, where the victim may report to them. And they commence asking intrusive questions when they're able to get the victim alone, maybe in an office, or taking them for a coffee. And both types of perpetrators typically vehemently deny any allegations of wrongdoing when it's put to them. And we've seen them in relation to some of the Me Too outings of a lot of these people in recent years. Next slide, please. The third slide from the Commission indicates that in the last 5 years, 41% of people have witnessed or heard about the sexual harassment of another person at work. And just over a third of those people took action to prevent or reduce the harm. And the majority of the people who took that action, 61% of them, said that the harassment stopped as a result. And that's a really critical issue. So it's the previous slide before that one, if you can get back one further. So having a culture where witnesses of sexual harassment are encouraged to speak up is one means of eliminating repeat conduct of many perpetrators. Not all of them, of course, but many. Okay, moving on, I'll now have a few slides in relation to the Kate Jenkins Respect at Work report. And can we go back a few slides, please? We're going forward at the moment, we need to go backwards. It's a one-headed overview RAW report. We're still going forwards, not backwards. There we go, backwards, back further, two more, I think it is, or three more. Keep going. Next one, that's it. Okay, so Kate Jenkins comments in her report. No, next one forward again, please. Kate Jenkins comments in her report that workplace sexual harassment is prevalent and pervasive and occurs in every industry, location and level. In my experience, that is 100% correct. She comments that sexual harassment causes financial, social, emotional, physical and psychological harm, especially for women. Again, that's 100% correct. And she refers to figures from the AHRC's 2018 survey, where there are estimates done about the cost of sexual harassment to the Australian economy in 1 year alone, and that was a cost of $3.8 billion. That's a staggering figure. She comments that most victims never report harassment, and that's a really, really damning issue in our current system. And also about half of our victims had previously experienced sexual harassment at the same workplace. So these are not one-off experiences often in offending workplaces. Next slide, please. So Kate Jenkins also looks at the cultural and systemic causes of this harassment, and that is particularly power disparities are the major contributor to these issues. And in turn from this, she says gender inequality is the key power disparity driving sexual harassment. Another driver is poor workplace culture, including inadequate leadership. And I've seen this in many workplaces over the years. Also, a lack of understanding about what constitutes sexual harassment. And this is a major issue. And frankly, inadequate brief online training modules do not assist this either. Also, the use of alcohol in a work context raises a red flag. And alarm bells, in my view, should always be rung where staff are drinking alcohol, whether at work functions, at conferences, at client or customer lunches. I've seen countless examples over the years of significant sexual harassment and sometimes sexual assault where either or both of the perpetrator and the victim have been drunk. And this has included managing directors and CEOs as perpetrators. Next slide, please. So Kate Jenkins also looks at the people who experience sexual harassment, excuse me, and she comments that from the figures, women are far more likely than men to experience it. And of course, that is no surprise. And also young workers who are less than 30 years old are more likely to be harassed. Again, there's no surprise there. And then she looks at different categories of people who often experience greater forms of other discrimination. They're also likely to more likely to experience sexual harassment. And they include groups like LGBTQI workers, Indigenous workers, those with a disability, those from culturally and linguistically diverse backgrounds. Next slide, please. Also migrant workers, those holding temporary visas, and people in working arrangements described as insecure. So these are often, or can often be, very vulnerable people. Next slide, please. So then Kate Jenkins identifies higher risk workplaces, and surprise, surprise, these are male-dominated industries because of the gender ratio, the overrepresentation of men in senior leadership roles, non-traditional workplaces for women such as mining or transport, workplaces with high levels of contact with customers, clients or patients. The retail and hospitality sectors are hotspots here, as are the healthcare and social assistance industries. She also identifies that workplaces with hierarchical structures, such as the police force, the Australian Defence Force, or indeed medical and legal professions, which are very hierarchical, they're also high-risk industries. Next slide, please. So, Kate Jenkins in her report also discusses at length the impacts of sexual harassment in workplaces, and these are massive. They involve lost productivity, staff turnover, a negative impact on workplace culture, employer resources associated with responding to complaints, litigation, workers' comp claims, and reputational damage for the business. And Kate makes the comment that sexual harassment often equates to gendered violence, and that's a focus of a fair bit of the material in the report as well. Next slide, please. So clearly something is needed to be done. It's been highly unsatisfactory for a long time. What's changed? Well, we now have a new positive duty under the SDA, and the aim is a laudable one, to shift the system from a reactive complaint-based process to a proactive one focused on prevention. In other words, to stop the conduct from occurring and take the pressure off the courage of victims having to actually make complaints. What is the duty? It's a positive duty on businesses and organisations to prevent 5 things: workplace sexual harassment, sex-based harassment, sex discrimination, hostile work environments on the ground of sex, and victimisation. And I'll give you an example of 2 of those issues, sex-based harassment and hostile work environments on the ground of sex, just to help describe them. Currently, there's a claim before the federal court involving a long-serving female Qantas pilot, Davida Forshaw, who's issued proceedings against Qantas for sexual harassment and sex-based harassment. Now, one of her allegations is that while she was attending an engineering briefing with other pilots, she alleges she was instructed to get coffees for her male counterparts. If that were found to be proven, then that could constitute sex-based harassment. Similarly, in relation to hostile work environments on the ground of sex, in the same Qantas pilot case, she states that she received a poor performance report after she rejected sexual advances from an airline captain. And also she states that she was told that she would do a lot better at work if she dyed her hair and wore a push-up bra. Again, if these allegations are established, then that could potentially constitute a hostile work environment on the ground of sex. The requirement here for businesses is to take reasonable and proportionate measures to eliminate this conduct as far as possible, and Richard Skugel will be talking a bit more about these requirements. Next slide, please. Briefly, the Act has a clause in it that provides factors that a court can take into account in determining whether an employer has been compliant with the requirements. And I'll let you look at these at your leisure, but essentially they involve the size of the business, the resources of the business, the practicability and cost of measures to eliminate the conduct. And by the way, there'd be very, very few measures that are not practicable or too expensive to introduce in order to minimise or eliminate this conduct. And the courts can also take into account any other relevant matter. And this is where particularly workplace culture becomes very significant. Next one, please. I mentioned before that there's a new obligation to prevent hostile work environments on the ground of sex. And the test here, this slide demonstrates, is exactly the same as the existing test for sexual harassment and sex-based harassment. So it's a reasonable person, having regard to the circumstances, would anticipate the possibility that the victim will be offended, humiliated, or intimidated by reason of their sex or a characteristic appertaining to it. Okay, next one, please. So they're the requirements, the changes in the Sex Discrimination Act. I'll now just discuss the Fair Work Act and changes and the Workplace Health and Safety amendments. Under the Fair Work Act, there's now a prohibition of sexual harassment. So a person must not sexually harass a worker, a person seeking to become a worker, or a person running a business. Who can seek these remedies? It can be a worker or multiple workers, so 6 people can bring a claim together at once. And unions or the Fair Work Ombudsman can also bring claims on behalf of victims. In relation to the remedies, the orders that can be sought, initially there can be a request for a stop sexual harassment order. If the matter goes further at the Commission can also mediate or conciliate the matter. And if it does, conferences must be held in private to protect victims and witnesses. And if the parties consent, the Commission can also arbitrate on the issue. And if there's no consent, then the claimant can proceed further to the Federal Court or the Federal Circuit and Family Court. In relation to potential orders there, that can include compensation, including for remuneration lost. There can be an order requiring any reasonable act or course of conduct to redress the loss, or an order that the perpetrator has engaged in unlawful sexual harassment. In addition, the Fair Work Ombudsman has new powers now. It can issue notices compelling production of documents and records and examine, interview individuals. Like workplace regulators can do now, the health and safety regulators, it can issue compliance notices to improve things in the workplace, as well as engaging in prosecutions or agreeing to enforceable undertakings. So that's the Fair Work Act. Finally, in workplace health and safety, most of you are probably aware that around Australia, in every state and territory and the Commonwealth, apart from Victoria, we have model or mirror legislation and regulations. These have all been recently changed over the last 12 months with mirror changes to the regulations. The last one to come in is in South Australia next month in December. In Victoria, they're not in yet, but they will be. And the driver behind these changes has been a report of Marie Boland into the Model Workplace Health and Safety Laws in 2019, but also the Jenkins report. And the problems identified by both of these two is that the obligations on organisations to address mental health issues in the workplace are not clear enough, including relating to sexual harassment. And in particular, Kate Jenkins comments that the issues these issues have led to sexual harassment not being addressed as a workplace health and safety issue, which it very clearly is, and these changes seek to amend that. So what are the requirements? There's a requirement on businesses now to identify psychosocial hazards, including sexual harassment and sex-based harassment. And once you've done that, there's a requirement to engage in what's always been the process in health and safety, just back to the previous slide, first of all, and that's engage in the holy trinity of health and safety to identify the risk, then assess the risk, look at the magnitude of the risk occurring, then likelihood of it occurring, and then put controls in place to eliminate where possible or reduce the risk if it's not possible to eliminate them. In going through these processes, really significantly, there's a requirement for you to consult with your workers at every stage of the process, as well as to review the control measures you put in place on a periodic basis to ensure they're up to date. Next slide, please. So I mentioned these regulations have been introduced everywhere in Victoria, except Victoria, where they've been on the drawing board for 18 months. They will be introduced here, and the proposed Victorian regulations are more stringent, particularly in two respects. If you identify a sexual harassment hazard in the workplace in Victoria, the requirement will be you must put a written prevention plan in place, which can be inspected by the regulator. And secondly, there'll be mandatory 6-monthly reporting requirements to WorkSafe about any complaint in your workplace involving sexual harassment in the previous 6 months, as well as some other hazards. So that's all from me for now. We'll have questions at the end, but I'll hand you back to Linda.
Thanks, David. As you've outlined, it is important for us to understand why these changes are necessary. What it emphasises is that organisations can do more to actively prevent workplace sexual harassment and discrimination. I think as leaders in an organisation, it is imperative that we set the standards for inclusion and equality and create a culture that is safe and respectful. So Richard now will discuss the Australian Human Rights Commission's new guidelines for complying with the positive duty. Richard is our Special Counsel at Hunt & Hunt Employment Law Team. Richard, I'll pass it over to you.
Thanks, Linda, and thanks, David, for the first half of our presentation. The first point to make is the Australian Human Rights Commission is responsible from the 12th of December 2023, and it'll have powers to enforce compliance with these new positive duties. It'll have a range of new regulatory tools to monitor, assess, and enforce compliance with the positive duties along the lines that David's just described in regards to some of the other regulators. While this represents another layer of red tape on top of the requirements that already exist in the regimes that we've talked about, and another umpire that can knock on the door and review workplace practices, the silver lining is that the Australian Human Rights Commission has produced some very good resources to assist employers to understand their compliance obligations. And central to this is their new guidelines, which the Commission will use to assess compliance from December. The guidelines are well set out and logical, and they make sense. They present obligations which are in a more contemporary way, but they also very closely reflect best practice in OHS compliance, and they should not be too surprising to people who are already complying with existing positive duties. The guidelines are intended to help organisations to understand their positive duty and set some standards which they should meet. And they also set out reasonable and proportionate actions that they can take to make sure they meet their legal obligations. All organisations must take proactive steps to eliminate this kind of conduct, but the actions that they take will be different for different organisations based on size and other factors that David has described. But everyone must meet the 7 standards. As well as 7 standards, the Australian Human Rights Commission has nominated 4 guiding principles to inform the decisions that organisations make. Employers will need to apply the guiding principles when implementing the 7 standards. The 4 guiding principles are consultation, gender equality, intersectionality, and person-centred and trauma-informed responses. Some of these have already been explained, so I won't go into them in too much detail, but briefly to outline what it means to be person-centred and trauma-informed. This means that workplace systems, policies and practices must affirm the safety and dignity of the people that they interact with and aim to improve their health and safety. Being person-centred means putting the individual who has experienced or reported unlawful conduct at the centre of the response, decision-making and planning of the organisation. It provides choices on how the organisation will respond. Being trauma-informed means understanding trauma and its impacts, supporting choice and control for the person affected, fostering safe and trusting relationships where disclosures of trauma are possible and where they're responded to appropriately, and understanding that recovery is possible for everybody. These concepts are set out in more detail in a fact sheet which is annexed to the Commission's guidelines. Looking at the 7 standards, these are leadership, culture, knowledge, risk management, support, reporting and response, monitoring, evaluation, and transparency. As you will see, these overlap, and initiatives in the guidelines will go to meet more than just one of these standards. The way that each is addressed in the Commission's guidelines is similar. First of all, the importance of each standard is explained, then the outcomes that employers should aim for are established. Then practical examples to meet these outcomes are listed in a table. Further examples are provided for medium to large organisations, which need to go further in most regards. And then a list of some of the records that can be used to prove compliance are set out. In some cases, templates and other resources are referenced, and these are listed in the endnotes of the guidelines. So looking through these standards one by one, starting with leadership. Senior leadership is obviously critical to set the tone within an organisation. They lead by example and have responsibility for the actions of others, as well as the allocation of resources and the oversight of compliance. The intended outcomes here are that senior leaders understand their obligations under the Sex Discrimination Act and understand what is unlawful conduct. Senior leaders must develop measures to prevent and respond to unlawful conduct and document this and share it with their workforce and see that it is implemented. They must be seen to champion positive behaviour, equality, fairness, and to drive workplace culture that is safe, respectful, inclusive, and diverse. The practical examples that are given in the guidelines for how an employer can meet the first outcome, that is, understanding the legal framework, are set out as follows. First of all, you must read the guideline material. Secondly, leaders may arrange subscriptions to updates from regulators, advisors, and peak bodies and share these within the leadership team. Senior leaders should attend quality education sessions on the laws and the application of them and update themselves regularly about their rights and responsibilities. Regarding the second outcome, the guidelines require the development of a prevention and response plan. There's a template of a prevention and response plan annexed to the guidelines. Larger organisations will need to go further to keep board members informed about education initiatives, employee feedback, and other relevant data. Next, the guidelines set out some examples of the records that will help to demonstrate meeting these standards, and these include documents such as the prevention and response plan that we talked about, evidence of consultation with workers in the development of this and other key initiatives, also reports to boards. But in particular, policies, codes of conduct, and senior leaders' contracts and position descriptions will show that the organisation treats this matter seriously and is leading from the top. The second standard is culture. Culture sets the parameters for what is acceptable and unacceptable and how unlawful conduct must be managed if it occurs. The outcomes here are a positive culture which values safety and respect, gender equality, diversity and inclusion. It enables reporting of unlawful conduct and minimises the harm and holds people accountable for their actions. On a practical level, there's an expectation that organisations will hold gender balance and diversity in mind when recruiting. There's an expectation they'll aim to increase representation and workplace inclusion of women as well as other diverse members of our community. They will consult with workers and listen to their lived experiences. Larger organisations may also develop equality strategy and positive discrimination initiatives. And entities in the public sector who are covered by the Gender Equality Act 2020, including Victorian public sector agencies such as local councils, will already be familiar with many of these reporting obligations. Likewise, private sector organisations with 100 employees or more have reporting obligations under the Workplace Gender Equality to the Workplace Gender and Equality Agency. If they're writing reports to these regulators, then there's a good chance that employers already understand the steps they need to take to encourage a positive workplace culture in this area. So records that you can keep, not surprisingly, are the reports that I've just mentioned, but also correspondence with workers and notes of meetings with workers showing how these matters are raised and discussed at a workplace level. induction manuals, organisational values, codes of conduct, as well as contracts and job descriptions where PDs of leaders set requirements for them to contribute to the development of a positive culture. The expected outcomes under the third standard knowledge are that organisations develop, communicate and implement a policy regarding respectful behaviour and unlawful conduct. They support workers, including leaders and managers, to engage in safe, respectful and inclusive behaviour through education. Knowledge across all levels of the organisation is important to eliminate poor behaviour. Workers must be educated about the positive duty, their roles in this, and the consequences when people engage in unlawful conduct. Education should be ongoing, and it should be linked to the values of the workplace. Not surprisingly, at the centre of this standard, and perhaps the centre of the guidelines altogether, is still a solid workplace policy and procedure document that regular staff training about its content. The policy and HR processes will document standards of behaviour, clearly explain what is unlawful behaviour and why it is unacceptable. The procedures will contain information about the reporting processes and consequences if poor conduct is found to have occurred. The Commission's guidelines include a section here which lists the expectations for minimum content in an appropriate workplace behaviour policy. Education should be trauma-informed and tailored to the roles and the responsibilities of the audience. Posters, the intranet and information sheets can all be used to help to educate workers. Larger organisations can publish the policies internally and make them a KPI or performance requirement for managers. They can also call in experts to provide education support and advice in response to certain areas and provide up-to-date learning styles that cater for diverse members of their workforce. Records that demonstrate actions to meet Standard 3 would include attendance records at training sessions, copies of the training content, written policies and procedures, as we've described, such as the appropriate workplace behaviour policy, and notes and agendas from toolbox talks or team meetings to show that knowledge is shared and at an informal level there as well as just at more formal training sessions. The fourth standard is risk management, and this is where these new guidelines dovetail very closely with the OHS models that David was talking about. The desired outcomes here are that the organisation recognises that unlawful conduct is an equality risk and a health and safety risk. They take a risk-based approach to prevention and response. This behaviour poses a risk to the psychological and physical health and safety of workplace participants. It can also violate the person's right to equality, non-discrimination and dignity. Since risk management is a requirement under existing OHS laws, it should already form part of an employer's prevention and response plan. This model involves consistently assessing the known drivers and risk factors in the workplace. For example, as David said, power imbalances and gender inequality have been found to be key drivers of some sorts of unlawful behaviour. Employers also have an obligation to be aware of those who are most impacted by this sort of conduct. Applying the OHS model, after risks are identified, effective control measures must be implemented to address the risks, and control measures are then must be reviewed and adjusted on an ongoing basis to make improvements. Some control measures that are relevant here include looking at the physical work environment and security arrangements, knowledge sharing with other businesses that share the same work site or location, lighting and workplace design, visibility and surveillance, safe work systems and procedures, proper supervision and staffing numbers, screening and reference checking new hires, protections when people are working off-site or at a different workplace, and also reviewing and monitoring and managing the conduct of third parties such as clients, customers and contractors. So practical ways to achieve some of these ideas to meet the standard include leaders making sure that they understand what sort of drivers constitute risks to equality, health and safety, and legal risks within their business. Leaders must continually seek out information about risks and available control measures. They should train people with skills to address this kind of misconduct. They need to take an OHS approach and regularly review industry-relevant guidance. They need to keep written records of risk management processes using risk management tools. And again, there is a risk management tool template referenced in the Commission's guidelines. In fact, it's the same tool that is referenced in the Victorian guidelines, which I'll talk about in a little while. Records to demonstrate actions that can be taken to meet this standard include exit interviews and surveys with staff, position descriptions for leaders, and the analysis of data that shows what has happened when things have been reported and how they've been managed. Also here, board papers and minutes to show how senior leaders are responding to risks and maintaining controls are important. Standard 5 is support. Organisations ensure that appropriate support is available to workers, including leaders and managers, who experience or witness unlawful conduct. Workers are informed about the available support, and they can access that support regardless of whether or not they have reported the conduct. So what does support look like? Well, it can be informal, such as facilitating leave if somebody is involved in an investigation and doesn't feel comfortable working in the same environment as the respondent to that investigation. They may make arrangements to change their working patterns or conditions to avoid interaction. On a formal level, support can be EAP, employee assistance programs, or hiring and engaging contact officers, and also running more formal investigations into reports. Support reduces the possibility of unlawful conduct by enabling people and organisations to address risks first. It also empowers people to make decisions to respond to conduct. Some practical examples of how to meet the support standard include making options available for staff to contact anybody within the organisation to report this sort of conduct. That includes owners, senior workers, health and safety representatives and union delegates. Explaining access to external supports as well, and these might be community organisations or EAP or regulators. It's important to be person-centred and make sure the person seeking support can ask about their options and they're supported to understand what their options are. In large organisations, support may include access to more sophisticated HR structures and contact officers, and it may also include culturally specific services and mental health first aid training and mental health first aid plans. Records to demonstrate compliance with Standard 5 include written materials such as posters, attendance records at training sessions, and evidence that support has been offered in particular cases, like individual cases, and records or evidence that EAP is available in an organisation with the means and the resources to support it. The sixth standard is reporting and response. Here, the outcomes desired by the guidelines are that organisations ensure that options for reporting and responding to unlawful conduct are provided and regularly communicated to workers and other impacted people. Responses to reports of unlawful conduct should be consistent and timely. They minimise harm to and victimisation of the people involved. Effective reporting and responses demonstrate that unlawful conduct is not acceptable. They build trust in the process and can help prevent unlawful conduct from happening in the first place. This can be done if the outcomes are fair and the consequences of actions are appropriate. There should be multiple reporting avenues and options open for resolution. Victimisation should be prohibited, and also dealt with robustly if it occurs. Some practical examples to meet this standard are that workers and other workplace participants know about their reporting options, including through posters, education, and inductions. There may be multiple pathways internally and externally to report. Anonymous reporting mechanisms and whistleblower hotlines might be established. Options are explained constantly and outlined clearly to people if they come forward with a report. People managing these reports need to have the appropriate skills to do so. In larger organisations or where the workforce is diverse, this might mean that the people who are handling reports are also diverse and are sensitive to any unique factors that impact the people who are coming forward. Records to demonstrate action here include a written procedure and policy, that outcomes are reviewed, that outcomes of consultation with workers are clearly evidenced, and data is maintained regarding reports, including the responses taken and the outcomes of those reports. The final standard is monitoring, evaluation, and transparency. Organisations collect appropriate data to understand the nature and extent of unlawful conduct concerning their workplace. Organisations use data that they collect to regularly assess and improve the workplace culture and to develop measures to prevent and respond to unlawful conduct. This standard is all about data. Next, organisations must also make sure that they are transparent about the nature and extent of the reported behaviour and actions that are being taken to address it. Now, this standard obviously overlaps with the risk management standard and some of the others as well. Under monitoring, data can be used by organisations to understand when, where and how unlawful conduct is occurring, who is doing it, who is impacted and why it is occurring. This information will inform the way that they respond. Many employers will already have been collecting data and reporting it internally and externally. They may also seek to collect data from externally. There might be publicly reported data which will assist them to understand the risks and drivers within their own workforce. The data can be used then to evaluate the risks and the effectiveness of control measures. It can look at the nature of the culture, the role of leadership, and the other standards that we've identified. In terms of transparency, de-identified data should be reported to senior leaders who are responsible for governance of the organisation. It should inform their continual improvement of the prevention and response plan. Data may also be shared with workers to assist in education initiatives, to increase trust in the organisation and to create positive change. So in terms of practical ways to do this, I mean, you need to collect data. External expertise may be used here, but data will look different depending on the size of the organisation. At the smaller end, this will involve asking questions to assess effectiveness of the control measures and performance against the expectations here. I might move on just in the interest of time now to just talk about some comparisons with some of the other regulatory regimes. Now, as we've said, in Victoria, there's already an existing positive obligation to address sexual harassment. The Victorian Equal Opportunities and Human Rights Commission published its own guidelines in 2020 for employers to meet the Victorian positive duty. It's very similar to the new federal guidelines, which isn't surprising given that the obligations in Victoria are very similar. People must take responsible and proportionate measures to eliminate discrimination, sexual harassment and victimisation as far as possible. The Victorian guidelines are limited to sexual harassment, although the obligations in the Act talk about elimination of discrimination and victimisation as well. Also, the structure of the Victorian guidelines, while ultimately addressing many of the same points, I would say are not quite as intuitive as the new guidelines published by the Australian Human Rights Commission. If you look at the 6 standards in Victoria, these are knowledge, prevention plan, organisational capability, risk management, reporting and response, and monitoring and evaluation. So we can see that there's a lot of similarities here, but in fact, in some cases, the same words are used to describe different things. In Victoria, knowledge really means knowledge of the leadership group. It talks about making sure that people at the top understand what their obligations are, whereas in the federal standards, knowledge means making sure that everybody across the organisation has information about what the rules are and where they can go to seek assistance and support. But ultimately, although it's structured in a slightly different way, the standards in Victoria and federally are very similar. The OHS regulations, both at a state level and federally, also have obligations to positive duties to deal with issues such as sexual harassment. Safe Work Australia has published some guidelines as well. These were published in January 2021. They're much shorter, only 20 pages as opposed to over 100. And they are very, very good, but probably not as in-depth as the ones in the federal guidelines. So how does an employer deal with all of these overlapping regulatory regimes? Well, my view is that you need to be across all of it. So it's important to understand the differences and similarities in all of them. But certainly the new federal guidelines are a very good place to start. What I would recommend is that you look at the Australian Human Rights Commission's guidelines and its collateral and identify from that, what are you doing already and what are you doing really well? You can maybe use a green highlighter to identify those ones. Then you can look at what you're doing already, but that you could do better and put those in a task to-do list. Next, you could look at what are you not doing at all, but which you could be doing or which you should be doing. And those will obviously need to be addressed as well. And finally, if there are any recommendations in the guidelines that you're not doing, but which really don't fit your organisation, then you should be able to explain why you haven't adopted those guidelines or those initiatives as well. So that concludes my part of the presentation. Now I'd like to hand over to Harriet to give us a case example from the Productivity Commission. Thank you.
Thanks, Richard. I'll just get you to keep clicking through the slides if possible.
That's fine.
Wonderful, thank you. So just next slide. Intersection is a consulting firm with expertise in transforming organisational culture to ensure safety and respect in the workplace. Intersection was engaged by the Treasury earlier this year to undertake a review of a complaint regarding the culture of and conduct at the Productivity Commission, which is an independent statutory agency undertaking research and acting as an advisory body to the government. Intersection's Principal Director, Natasha De Silva, and Principal Consultant, Trish Lowe, worked closely with the former Sex Discrimination Commissioner, Kate Jenkins, to prepare the report. The consultation was conducted across the Canberra and Melbourne offices and undertaken between the 2nd of Feb and 1st of August this year. It had 26 anonymous current and former Commission staff participating. Intersection was initially tasked with investigating a single complaint of sexual harassment and sexism. It attempted to identify whether the complaint related to one or more incidents, the length of time the complaint referred to, and the number of people involved. In conducting its inquiries, the review discovered a number of other inappropriate workplace behaviour incidents, such as bullying and victimisation, which occurred primarily in the Canberra office, occasionally in the Melbourne office, and involved a small number of people. Next slide, thank you. Intersection adopted the framework of the Australian Human Rights Commission's National Inquiry into Sexual Harassment in the Australian Workplaces Respect at Work report, identifying drivers and risks that contribute to the occurrence of inappropriate workplace behaviour. These drivers and risks are closely aligned with the guiding principles of the AHRC's guidelines for complying with a positive duty under the Sex Discrimination Act. Drivers of inappropriate behaviours are considered to be structural and systemic factors that create an enabling context for those behaviours to occur. Drivers exist at a societal level more broadly and are therefore found both within and outside the workplace. In the context of the Commission, the drivers of inappropriate behaviour were found to be a lack of diversity and corresponding inequality, a lack of accountability, and power imbalances. On the other hand, risks relevant to inappropriate workplace behaviours are considered to be context-specific features that, when combined with the drivers, have the capacity to influence the occurrence of inappropriate behaviours. The review identified the Commission's risk factors to be 1, a people leadership deficit. This is because technical skills were often prioritised over people who had people management skills in promotional rounds. Consequently, senior personnel, who often had very good intentions, seriously lacked people leadership skills. 2, a high performance culture and contestability. The Commission was described as having a work hard, play hard, win at all costs culture, which was shaped and reliant upon the often adversarial contestability of ideas to inform their research. And 3, short-term project delivery and workload, as the nature of the Commission's project work was short-term and high pressure. Evidently, the prevalence of both drivers and risks increased the risk of inappropriate workplace behaviours occurring. The following experiences were shared to the report during the consultation period. Over the course of one participant's tenure at the Commission, the participant was subjected to repeated sexism, belittling, humiliation, and verbal abuse, including overt criticism of the female assistant commissioners, such as being told that they were promoted on the basis of their gender rather than merit, degrading the participant's performance, saying to them that, quote, he didn't expect them to last much longer at the Commission, and the Commission shouldn't bother investing time in them, end quote. Referring to the participant's work as pathetic, tasking the participant with work to complete in an unrealistic and unreasonable time frame, and undermining the participant's performance over the telephone to a third party. Another participant shared that over a period of 1 to 2 years, a number of women left the organisation and confidentially disclosed that they were, quote, sick of having their intelligence undermined, end quote, and that their views were not received in the same way men's were. From both the Melbourne and Canberra offices, the review heard examples of discriminatory behaviour towards people with a disability, such as not being afforded requisite, reasonable and required adjustments to carry out their work. Several review participants also noted that race featured in experiences of inappropriate behaviours at the Commission. A number of culturally diverse women felt excluded from the workplace, leading them to feel unseen and unheard. As per the guiding principles, understanding these intersectional factors is important because it highlights how a person's experiences can be compounded by the forms of inequality that they face. The review found that a large majority of inappropriate behaviours have fallen largely under the radar and were not addressed adequately when brought to management's attention informally. This was said to have increased the occurrences of inappropriate behaviours and created a psychologically unsafe environment for women and those from minority groups. The review noted that a lack of management proactivity, quote, has been a missed opportunity by leadership to take a preventative action to reset the culture and communicate behavioural expectations and consequences of breaches, end quote. In the limited number of complaints of inappropriate behaviour made formally, the Commission followed their workplace behaviour policy and procedure. However, it was evident to this review that there was a lack of a trauma-informed response for those who did come forward. On some occasions, the review participants stated that they did not know where they should go to report an incident, either formally or informally. Numerous participants also referred to the Commission's human resources team as a black box and reported feeling interrogated or victimised by HR after making a report of inappropriate workplace behaviours. There were also concerns about HR not adequately or appropriately supporting supervisors in managing staff exhibiting these inappropriate behaviours. Intersection considered that the effects of these experiences may have resulted in some staff not feeling comfortable to report or disclose through either a formal or informal process. With all of that being said, the Commission has recently introduced sound frameworks and policies consistent with the Respect at Work recommendations. To further comply with the Respect at Work positive duty and the Code of Practice on managing psychological hazards at work, Intersection made 23 recommendations which are critical to address the drivers and risks it identified in the review. These recommendations are consistent with the AHRC's guidelines for complying with positive duty under the Sex Discrimination Act. The recommendations of the review surround leadership and culture, risk identification and mitigation, policies, support, reporting and accountability, and measuring and transparency. By way of example, to address leadership and culture at the Commission, Recommendation 5 proposes that all leaders be trained in a trauma-informed, victim-centred approach so that they can respond to disclosures of inappropriate behaviour in a manner that ensures complainants are supported and no further harm is caused. to address risk identification and mitigation. Recommendation 8 proposes that recruitment for leadership positions prioritises people and leadership management skills and experience in addition to technical knowledge and skills. On the slide, you'll also see that there are several other recommendations from each category. Intersections recommendations ultimately provide an opportunity for the Commission to reset the culture, create a safe and inclusive workspace, and ensure that future incidents of inappropriate workplace behaviours are dealt with swiftly and efficiently.
Thanks, Harriet. On our next slide, we've provided links to a few helpful resources that were referred to in this webinar. I am conscious of time, but we might have time for a question. If anyone's got a question for Richard, David, or Harriet, happy for you just to raise your hand or type in our chat box. No questions? Nothing's coming through? All right. If we don't have any questions, I'd like to thank you for being with us this afternoon, and we hope you've benefited from this webinar. We'll be doing regular webinars moving forward, so if you have a specific topic you'd like us to discuss, please reach out to us. On the next slide, you'll see Richard and David's contact details. Thank you, everyone.